floor test ought not to take place. Only a no confidence motion could be moved in such a situation. And Dr. Singhvi said that where disqualification petition is pending, my answer is zero as far as holding of a floor test is concerned. Now, my lords, with utmost respect, these submissions of the petitioners are in the teeth of 9 judges of this honorable court in Bomai, are in the teeth. We are told that the concern in this matter is not about who wins and who loses, but maintaining constitutional propriety and institutions. And I think the arguments sought to be now forwarded before your lordships are destructive of the entire constitutional scheme as settled by your lordships in a catena of decisions, including the 9 judges in Bomai. Also reiterated in Shivraj Singh Chauhan's case, where your lordships relying on Bomai said that it is incorrect to say that the floor test can only be directed to be ordered by the governor before a ministry formation and not after. In fact, your lordships' words used in Bomai and Shivraj were, it is the duty of the governor to hold a floor test. The only constitutionally ordained forum is the Assembly of Parliament, and no governor or individual in his own opinion can form a view whether a majority has been won or lost, and the only way forward is a floor test. And the court frowned upon the tendency because there used to be a huge misuse of Article 356 to dismiss governments and dissolve houses. So there was, the courts frowned upon it and said that the first instance, the governor must call for the floor test in such matters. Now, my lords, what happens in this case? In this case, on the 27th, and in my earlier submission before your lordships on Navam Revia, I had even then said that I'm not for a minute suggesting that when we filed our 32, Navam was not one of our cases. That's not our contention at all. Navam was one of our important arguments. The other was equally important, was violation of principles of natural justice. And the third was imminent, immediate danger to the lives of the MLAs whose houses were being burned and relatives being threatened. That is why we came in a 32. And that is hugely different and was not barred by Quixote at all. Because our contention was not that your lordship decides on the disqualification petitions, as they are claiming. That was not the prayer in our petition. Our contention was that Navam, even as it stands today, has held the judicial field. It is a constitution bench decision, and the speaker had no jurisdiction to proceed with the matter at all, apart from the principles of natural justice being violated. The court, keeping all this in mind, only on the issue of natural justice on that day, extended the time, did not injunct the speaker, extended the time. Now, extension is interpreted to say because extension was granted till 12th of July, it effectively meant an injunction. I don't see how. If you violate a provision of the rules which says adequate notice should be given, the speaker doesn't give that notice, the Honorable Court says gives them more time. Now, after that, my lords, what does the governor do? The governor in his letter writes to say that 7 independent MLAs who were supporting a ministry have withdrawn support. The leader of the opposition has written to me to say that they have no confidence in the ministry. Within the ministry, a large section of the legislative party have moved a resolution saying that they do not support the MVA ministry and government. Given these facts, I think it prudent and call upon the then Chief Minister, Mr. Thackeray, to come and prove his majority on the floor of the House. Lords, I put a question to myself, what else is the speaker, the governor expected to do? Your lordship's words again in Bomai are, by whatever process or means. The words used by your lordships in Bomai are, by whatever process or means, the governor can gather the information that is required, which raises a credible doubt as to the majority of a government in power. The only course open is a floor test. And that is what the governor goes ahead. You refuse to face that floor test. And your only answer to that is, it was a fait accompli. So, my lords, if democracies which have to be tested on the floor of the House are going to be decided on, it's my fait accompli, so I won't go and face a floor test, and yet want to continue in government, is that acceptable? Is that constitutionally acceptable? The only mechanism known is a floor test, and you evade that. And then you cast aspersions on a constitutional authority to say, which in any case today is the norm, you can cast any aspersion on anyone you want to. And you say that the governor in question failed to discharge his duties, acted with bias in a mala-fide manner. Because what was he expected to do? 7 independent MLAs say we have lost confidence. The leader of the opposition writes, 34 of the 55 MLAs pass a resolution saying we have no faith in the ministry any longer.